Hey everyone, my name is Kurt Lozer, and for this week's module, we're going to be discussing hazing in higher education. We're going to be discussing two primary cases. The first, Lloyd versus Alpha Phi Alpha in Cornell University from 1999, and then Halmon versus Lane College from 2020. So I wanted to give a quick shout out to Carlos for giving me a style and template to run with. Thank you. So this is the overview, and today we're going to be discussing, as I mentioned, hazing. First, we're going to define what hazing means, and then kind of get into the Clery Act, which kind of sets the standard and foundation for hazing legislation moving forward. We're going to talk about some more anti-hazing legislation following that, as well as kind of the differences between states here in America. And then finally, we'll get into Lloyd v. Alpha Phi Alpha from Cornell University, the procedural history and the ultimate decision. Then we'll get into Halmon versus Lane College, procedural history and the decision. And then I'll briefly discuss the significance of the cases and why I believe they're important to student affairs. And then finally, I wanted to just quickly touch on the Gordon Foundation or the Gordy Foundation and the Gord Center, which centers on a student back in 2004, not to date myself, but during my undergrad at CU Boulder, who was a victim of hazing and since has parents have created a foundation to sort of address and hopefully stop hazing in collegiate settings. So before we get into the cases, I thought it was important to establish what hazing is. Hazing is defined as any activity expected of someone joining or participating in a group that humiliates, degrades, abuses, or endangers them, regardless of their willingness to participate. The definition of hazing typically includes components like a group context, the aforementioned humiliating, degrading, or endangering behavior, and it occurs regardless of consent. That is, if an event is going to take place and one person of the group decides that they are unwilling to participate, that event still occurs. And honestly, sometimes the person who is reluctant to participate will receive even more severe or harsh punishment as sort of a product of their own autonomy and self-preservation. And while hazing typically occurs in the context of fraternity and sorority houses, studies show it is more widespread among athletics, marching bands, and other performing arts groups, honor club societies, sport clubs, and even student government organizations. The groups in which hazing occurs are typically desirable, and students will spend countless hours building these relationships and developing leadership skills that they will draw upon throughout their lives. And so I think this is where the willingness to participate with these kids becomes forefront. They focus on powering through adversity rather than the pain and degradation and torture that they're subjected to. A piece of legislation that I thought was relevant when discussing hazing is the Clery Act of 1990. It originally began as a federal law, an amendment to the Higher Education Act of 1965, and its primary goal was to increase accountability and transparency for institutions of higher education. It mandated that institutions must report hazing incidents as a part of their annual security reports. It also required to provide educational programs to prevent hazing and promote a safer campus environment. Failure to comply with this Clery Act can result in penalties, including fines and potential loss of federal funding. So, in the last 30 years, I believe that it stands as a crucial piece of legislation promoting safety and awareness and anti-hazing rhetoric and through mandatory reporting. Subsequent laws and amendments have collectively contributed to creating safer campus environments and holding organizations accountable. And while this act was originally created as a measure to protect students from harm, it was expanded to include hazing, relationship violence, and other forms of abuse that may deter student success. Um, so I included a bunch of information here, and in lieu of trying to stay under the 15 to 20 minute cap, I won't read everything, but as with you'll see with many slides, the information is here for you to peruse and go back to as you see fit. So just some quick updates on some modern anti-hazing legislation. The Higher Education Opportunity Act of 2008 further amended the Clery Act by introducing the need for immediate campus emergency response and evacuation procedures. These other two, to my knowledge, and getting dates on them was a beast, so you have my apologies, have yet to be voted in. But you can see that they both kind of deal with education and prevention programs as well as standard definitions. And the definitions is just so that there's less subjectivity when some of these cases go to trial. So briefly mentioned under the Higher Education Opportunity Act, each state actually has their own set of hazing laws. And the question within each state isn't, is hazing bad? It is. It's unlawful, and its purpose can be achieved in countless other more healthy ways. The question really is, how severe is the hazing? Who can be held responsible? Who was liable for hazing injuries? Was it foreseeable? And what are the responsibilities for the surrounding university where the events occurred? It is estimated that on average a hazing death has occurred every year since the mid 1900s, but anti-hazing laws are uneven at best and sometimes non-existent. As you can see, 44 of the 50 states have laws that either include consent or without consent, but 6 are just completely absent. And so one wonders how they address hazing issues that come up, or if they're just so rare that they don't need their own legislation for it. But I just thought that this was a great way to kind of elicit that. Of course, in our country, though you have sort of, things at a federal level, once you get down to the state, rulings can be different, even if the exact same circumstances happen in Indiana and Kentucky, for instance. So it's just something that is interesting because, again, we all agree that hazing is bad, but within that there's a lot to be argued, a lot to be debated, and a lot of money obviously involved in the outcome and decisions of those events. And so finally to Lloyd versus Alpha Phi Alpha and Cornell University. Real quick, on both of the cases we're going to be discussing today, I kind of put the plaintiff's argument or side on the left and the defendant or the university fraternity's charges on the right. So you can kind of compare and contrast how they interpret the case, as it were. But in this one, we have Sylvester Lloyd Jr., who transferred to Cornell University in 1994 and very soon after pledged Alpha Phi Alpha, which is the oldest African American fraternity in the US, as well as the Alpha chapter at Cornell. Within a couple of weeks of rushing, the initiation activities began, and from January 16th to about March 12th, 1995, he endured physical beatings and torture, psychological coercion, and embarrassment. Some of these activities, as we note on the third bullet point, occurred in an Alpha chapter house on Cornell grounds, which sort of made them potentially liable. Above all these transgressions, Mr. Lloyd was suing for negligent supervision and control, premises liability, and breach of implied contract. And on to the procedural history. Without going into too much detail, I'll just spoil it for you and say that the court granted the university's motion to dismiss. In lieu of time, I don't want to read every last bit, and you'll have to accept my apologies for being so dense. There's so much important information that was related to the decisions that were made that I didn't want to leave anything out, but also I realize it's impractical to read everything, so I'll just kind of go over it quickly. The court found that Cornell had no real duty to control the behavior of the fraternity and that they had no knowledge of the activities, and that even though they monitor the fraternity, they intervene in the membership process and permit use of the fraternity activities, including the house itself, to host functions and events. There was really no duty that they saw for the university to protect a student. And then the plaintiff Lloyd, he failed to show constructive or actual knowledge of Cornell in regard to hazing, and that Cornell really never made any specific promises that could be deemed part of an implied contract. And finally, in relation to the other defendants, that even if Lloyd had assumed the risk of his injuries, this would not bar recovery for damages. So thus, if he assumed the risk, his damages would be reduced by the percentage of his culpability, which is, another way of kind of in the bottom right. It's just that in the student code of conduct, you have to refrain from hazing, and therefore, whether that's a participant or a host, anyone participating is sort of illegal. So whether you're the victim or the perpetrator, in the eyes of the law, you're both just wrong. And on to the decision that was made that I previously just spoiled for you. The court found in favor of the defendant that they had no duty to control the behavior of the fraternity, and that while potentially the hazing was foreseeable, they didn't have any concrete knowledge of the events that were going to transpire. Additionally, Mr. Floyd failed to put forth any evidence to prove his claim that a duty existed on Cornell's part as either a landowner or surrounding university to control the behavior of the APA members. And therefore, their motion to dismiss was granted, and they were ordered that they were no longer party to the action. To our second case of focus on the week, we have Halmon versus Lane College 2020. Similar to Lloyd versus APA, Deodric Halmon was a student who rushed Phi Beta Sigma in 2019 and experienced hazing, resulting in being regularly blindfolded, beaten, paddled, burned by candles, deprived of sleep, and compelled to drink numerous concoctions, one of which included a live fish and the other lighter fluid. He alleged that he had been seriously injured as a result of the hazing and experienced nausea, vomiting, dehydration, and complete renal and kidney failure as a result of the paddling, which required extensive hospitalization. As a result of this hazing, he sued for negligence and vicarious liability. However, due to his participation, summary judgment was granted on behalf of Lane College, and the trial or the case was basically dismissed. And real quick, a summary judgment, I'm just going to kind of verbatim this guy, is a legal decision made without a trial. A trial court should grant summary judgment only when the pleadings, depositions, answers to interrogations, and admissions on file, together with the affidavits, if any, show that there is no genuine issue as to the material fact and that the moving party is entitled to a judgment as a matter of law. Conversely, a trial court should not grant summary judgment when genuine issues or disputes of material fact are present. A dispute of material fact is that which must be decided to resolve the substantive claims or defense at which the motion is directed. So essentially, it's just, taking what the information is and making a quick decision based on the facts present. The procedural history in this case was an admittedly unusual one by the transcript standards, in that it granted summary judgment in favor of Lane College and quoted Morrison versus Kappa Alpha Psi fraternity in Louisiana of the same year as saying that youthful college students may be willing to submit to physical and psychological pain, ridicule, and humiliation in exchange for social acceptance, which comes with being a membership in a fraternity. Basically, he was at least 50% or more at fault because he was a willing participant. The difference is that Louisiana, as we have seen in my map, and Tennessee have very different consent laws, and therefore I think that's where we get the month and a half later, the appellate court acknowledged the facts, granted summary judgment that there was potential liability to one of the faculty advisors who had informed the plaintiff that there would not be any hazing. So, and they actually made it clear that the trial court was premature in granting judgment, and that, he might not have been indisputably 50% more liable for his own injuries. Um, and on the right, we have the vicarious liability. A Calvin Walker, a faculty advisor, was the person of interest whose testimony was not really admitted when they granted summary judgment. And once his role in the entire thing, including not only not intervening and preventing hazing, but participating in it after he had elicited that there would not be any hazing, sort of changed the court's view of how to rule. Um, and just a small side note: 95% of hazing victims do not report, the events to campus officials, and I think this is why willing submission is no longer a sound argument, because I think, I kind of think of it as, if I accept a ride home from you and you deliberately crash into a tree, am I complicit in my own injuries? And I think that's kind of where some of this gets to be debated, is that simply because they participated doesn't mean that they were active or willing to go along with all of the events and all of the punishment or torture that they would then be sort of subjected to. The decision in Halmon versus Lane College was an interesting one, as that the judgment of the trial was reversed in part and affirmed in part. Lane College did win a small point of appeal, in that Halmon's argument was that the university owed him a duty of care based on the faculty advisor, Mr. Walker's involvement, not only his knowledge of the hazing, but then his potential participation in the hazing, and of course his failure to stop the hazing. The court agreed with Lane College in that he his conduct was beyond the scope of his employment, and therefore the college could not be held responsible for his conduct under the theory of respondite superior. However, and that he wasn't liable for any alleged intentional torts based on his engagement. However, the Court of Appeals made it clear that the college could be liable for the faculty advisor, Mr. Walker's negligence in, as I mentioned, failing to intervene, stop, and report the hazing that Mr. Halmon suffered. On to the why. Why is hazing important to student affairs? Hazing is a form of interpersonal violence that will endure without strong and supportive preventative measures, including federal policy, to help communicate and define the expectations for safe campus communities. Since 2021, there had been at least one university hazing death each year from 1969 to 2017, with over 200 occurring in a 10-year span of 2008 to 2017, alcohol being the leading cause of death. It's essential for all institutions of higher education to take hazing seriously, to implement preventative measures, and educate students about the risks associated with participating in such activities. Reviewing these cases that mercifully did not end in death, I just kind of listed some keywords that I found that are troubling about hazing. They're persistent, that even though they're illegal, they still happen. They're universal. From California to Maine, they occur. And again, even though they're illegal, things happen, they get out of control, and tragedy occurs. Tragic, death being, even in the cases I reviewed today, having hospitalization for something that you participate in it's tragic. Especially when it's with friends and brothers and people you trust and whose opinion you regard. To be somewhat betrayed by that is emotionally and mentally hurtful, in addition to whatever physical ailments that you suffer. They're inhumane. I think that's the point of it, is that you have to prove yourself, and they're unlawful, as we've just figured out today, and they're evolving, which is good and bad, as we figure out who's in charge, who's in trouble, who's liable, who participated willingly, unwillingly, who lied. So there's a lot of things involved, but at the end of the day, we know hazing is bad, and there's just so many ways to achieve, uh, I guess, the tenets or whatever good people believe comes from hazing. So many better, more productive and constructive ways to, you know, test someone's loyalty or devotion without, you know, defaulting to these methods. Real quick, I wanted to go over this final story that sort of relates me to this hazing incident. In my undergrad, back in 2004, Lynn Gordy Bailey Jr. died of an alcohol overdose at CU Boulder at a Chi Psi fraternity hazing event. And this fraternity actually was only a couple blocks from where I lived. And this story, though I had never met him and never knew anyone in that fraternity, always kind of stuck with me. Um, and I think his story is a lot like a lot of other stories that we highlight in hopes of awareness and attention. Is that he was a young guy who had a lot going for him, a lot of friends, great social group, and his life was cut tragically short by decisions that he made, but also by those who he trusted, including not calling for any medical assistance when he was left to sleep it off and was clearly struggling to breathe and live. As such, his parents created the Gordy Foundation to promote awareness and, you know, attempt to pass more anti-hazing legislation that we'll see in a couple slides. So as I mentioned, the nonprofit Gordy Foundation was founded in 2004 in Dallas, Texas, Gordy's hometown, dedicated to his memory. It served to create and distribute educational programs and materials to reduce hazardous drinking and promote peer intervention among young adults. Um, the biggest thing that came from this was Save a Life, Make the Call. And I think this was directly related to Gordy's condition in that, posthumously looking back at all the events, had someone just called 911 when he was either face down or, rolling around and found in multiple different positions throughout the night, that he would still be alive today. And then in the summer of 2010, the Lanahans, his parents, stepdad, and his mom moved the foundation to their current home at the University of Virginia, and it became now known as the Gordy Center. And it provides life-saving education to college and high school students nationwide and other families whose close ones have been lost to hazing incidents. And finally, just some fallout from Gordy Bailey's passing. The CU Student Code of Conduct's hazing policy was expanded in recent years to include any forced violation of university policy and/or local, state, or federal law. And this broad language, I believe, was sort of included to catch some of the violations that might slip through the cracks. Let's remember, Colorado is a no consent clause state, and I believe that might have changed in recent years because of cases like Gordy, where just because he was a willing participant does not mean that those involved are just free of any blame or lawful action. And also the Interfraternity Council, or IFC on the Hill, has spent tens of thousands of dollars in recent years in the city to hold informative trainings on alcohol abuse, hazing, sexual assault, and other topics crucial to campus safety, as well as destigmatizing Greek organizations and cultures. In their defense, let's remember that while fraternities are notorious for hazing incidents, we find out through studies that it's actually marching bands and other, clubs that might actually be more to blame for these awful events from occurring rather than fraternities. I'll finish with a quote that I found by Charity Matters on the Gordy Foundation website that I think is not only relevant but uplifting in light of everything that I've read and researched in making this PowerPoint. Thank you all for sticking by me for now 25 minutes. I am anticipating reading your comments, and hopefully I've informed you on a couple things pertaining to hazing that you can either take with you or share with others. Thanks again. Appreciate your time.